Hello, we're picking up at part 7. Motion to reconsider Judge Allen's October 27th, 2009 order. They, constructive trusts, arise when the legal title to property is obtained by a person in violation, express or implied, of some duty owed to one who is equitably entitled. Defendant/plaintiff Patricia Gray sufficiently pled and established the necessary elements for this count in the amended joinder complaint and new matter. Plaintiff/defendant Perry did not address these elements in any of her pleadings or at the rule returnable hearing October 27, 2009. G. New matter, replevant. In order to sustain replevant, Mrs. Gray must show that she has title or rights to money and the funds are in the possession of the defendants. Commonwealth v. Dean, 245 PA Super 322. Second citation 369, Atlantic 2nd edition, 4/23/1976. Mrs. Gray's averments in the lawsuit clearly indicate that the defendants collected her share of the rents and that she did not receive the money from the defendants. Defendant/plaintiff Patricia Gray sufficiently pled or established the elements necessary for this count in the amended joinder complaint and new matter counterclaim. Plaintiff/defendant Perry did not address these elements in any of her pleadings or at the rule returnable hearing October 27, 2009. H. New matter counterclaim, unjust enrichment. Unjust enrichment requires a showing of benefits conferred on defendant by plaintiff, appreciation of such benefits by defendant, and acceptance and retention of such benefits under such circumstances that it would be inequitable for defendant to retain the benefit without payment of value. Steyer v. Hugo, 619, Atlantic 2nd edition, 347. Second citation 350, or excuse me, that was a pinpoint at 350, PA Super 1993. In order to prevail, plaintiff is required to show the existence of three elements. To establish unjust enrichment, a plaintiff need demonstrate three elements, which are: 1. Benefits conferred on defendant by plaintiff. 2. Appreciation of such benefits by defendant. And 3. Acceptance and retention of such benefits under such circumstances that it would be inequitable for defendant to retain the benefit without payment of value. Mitchell v. Moore, 729, Atlantic 2nd edition, 1200. Pinpoint 1203, PA Super 1999. In determining whether the doctrine applies, the focus is not on the intention of the parties, but on the result. Ameripro Search Inc. versus Fleming Steel Company, 787, Atlantic 2nd edition, 988, pinpoint 991, PA Super 2001. This makes it critical that the enrichment of the defendant be unjust. Steyer v. Hugo, 422, PA Super 262, pinpoint 268, second citation 619, Atlantic 2nd edition, 347, pinpoint 350, 1993. Defendant/plaintiff Patricia Gray sufficiently pled or established the elements necessary for this count in the amended joinder complaint and new matter counterclaim. Plaintiff Defendant Irene Perry did not address these elements in any of her pleadings or at the Rule Returnable hearing, October 27, 2009. I. New matter, counterclaim, negligent misrepresentation. Negligent misrepresentation requires proof of 1. A misrepresentation of a material fact. 2. Made under circumstances in which the misrepresenter ought to have known its falsity. 3. With an intent to induce another to act on it. And 4. Which results in injury to a party acting in justifiable reliance on the misrepresentation. Bookright Contractors versus the Architectural Studio, 581 PA 454, second citation 866, Atlantic 2nd edition 270. The Supreme Court in Bookright Contractors, Inc., Architectural Studio, specifically adopted Section 552 of the Restatement of Torts concerning negligent misrepresentation, which states in pertinent part, information negligently supplied for the guidance of others. One who, in the course of his business, professional employment, or in any other transaction in which he had a pecuniary interest, supplies false information for the guidance of the others in their business transactions, and is subject to liability for pecuniary loss caused to them by their justifiable reliance upon the information, if he fails to exercise reasonable care or competence in obtaining or communicating the information. Each defendant owed Mrs. Gray the duty of complying with her request for keys to the property, copies of the leases, not using her share of the rents to make repairs or pay taxes without her approval, not allowing the property to devaluate by failure to make rental increases or impede Mrs. Gray from doing same and remittance of her share of the rent in accordance with her request of same. None of the defendants complied with any of her requests. Moreover, like any action in negligence, there must be an existence of duty owed by one party to another. Bortz 729, Atlantic 2nd edition, at 561. Defendant/plaintiff Patricia Gray sufficiently pled or established the elements necessary for this count in the amended joinder complaint and new matter counterclaim. Plaintiff/defendant Perry did not address these elements in any of her pleadings or at the Rule Returnable hearing, October 27, 2009. J. New matter counterclaim, fraudulent misrepresentation. The elements of fraudulent misrepresentation are well settled. In order to void a contract due to a fraudulent misrepresentation, the party alleging fraud must prove by clear and convincing evidence a representation which is material to the transaction at hand, made falsely with knowledge of its falsity or recklessness as to whether it is true or false, with the intent of misleading another into relying on it, justifiable reliance on the misrepresentation, and resulting injury proximately caused by the reliance. Louis J. Pareco versus Susan J. Pareco, citation omitted. However, in this matter, there exists ample evidence of the existence of common law fraud. To prove common law fraud, a proponent must show 1. Representation, 2. Which is material to the transaction at hand, 3. Made falsely with knowledge of its falsity or recklessness as to whether it is true or false, with the intent of misleading another into relying on it, justifiable reliance on misrepresentation, and the resulting injury proximately caused by reliance. Gibbs versus Ernest, 538 PA 193, second citation 647, Atlantic 2nd edition, 882, 1994. Defendant/plaintiff Patricia Gray sufficiently pled or established the elements necessary for this count in the amended joinder complaint and new matter counterclaim. Plaintiff-defendant Perry did not address these elements in any of her pleadings or at the Rule Returnable hearing, October 27, 2009.